When we left you folks, we were talking about the process of filing a Chapter 7 case. Before you get ready to file your Chapter 7 case and sign the final papers, you've got to do one thing. Congress came out in 2005 and said you've got to do a credit counseling course prior to filing bankruptcy. Now, what happened? It started a cottage industry of all these different types of credit counseling companies who got certified by the U.S. Trustee's office and said, okay, now we're credit counselors. We're going to try to help you out. Great. The reality is, what does credit counseling serve? What purpose? It serves zero purpose, in my opinion. I've had a couple clients who went through it and said, yeah, it was kind of nice, and yeah, I learned a few things, but there's nothing you're going to learn in there that that's going to help you at any point in time before you file. I'm sorry. It's a ridiculous requirement, in my opinion. Probably get in trouble for saying that, but you know what? Who cares? When you're sitting with your attorney prior to filing your case, hopefully you have your credit counseling done, paperwork's in order, you go through each page of that petition and schedules, each page line by line. And at some point in time, we want you maybe to initial each page so that we know you've read it, you've understood it, and you've agreed with it. Any changes that need to be made then before the case is filed. Okay, what happens then? In Southwest Florida, we do what's called electronic filing. So either myself, one of the attorneys, whatever, we'll file the case. Click, 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 bam, it gets filed with the court. Just like that. Eventually, we're going to get a case number back, and we're going to get what's called a notice of meeting of creditors. That's the only real hearing that our clients are going to have to attend. And it's a good thing. It's a good experience. I think it is anyway. It's an opportunity for the creditors to come and question the debtors on anything that they might have which is relevant to the case. For example, you owed us money, you took money out, you did this, you did that. That's fine. I have no problem with the creditors being invited to the meeting of creditors or the debtor being invited to the meeting of creditors. The reality is, though, no creditors ever show up. I don't know why. There may be times where it's relevant to send a creditor, and sometimes they do if it's a big commercial case or if their debtor has a business or something to that effect. But overwhelmingly, no creditors ever show up to the meeting of creditors. There may be some times where you're sitting there reviewing with the documents with your attorney, and it may not be a good time to file your case. Let's say, for example, within 90 days prior to filing, you had a large purchase because you had to fly up north for one situation or another. Your grandmother's 90th birthday. You fly up north, you buy plane tickets. Well, if that's seen as a luxury item, technically, that creditor could actually come into the bankruptcy court and file a lawsuit against you and try to have that debt declared non-dischargeable. So you got to be real careful in that meeting with your attorney before you file the paperwork that nothing has changed in that last couple of months. Let's go ahead now. We've already filed the case and we're waiting. What happens in the next several days? Well, once you file your case, an automatic stay goes into place. And this is one of the, what I call one of the cool things about bankruptcy. Not a lot cool about bankruptcy, but, we find our little things. The automatic stay is an injunction that goes into place immediately upon your case being filed. No creditor can take any action. That's what the code says. No creditor can take any action to attempt to collect the debt. Now, that's been watered down by cases over time where judges have said, well, this, that, and the other thing could happen. But the reality is that the code specifically says no creditor or a creditor cannot take any action. In other words, any creditor whose claim is stayed by the filing of the case. There are certain times where some actions may not be stayed, but those are exceptions to the automatic stay. And again, the show is only 30 minutes. We can talk about that for days. In your situation, or the majority of the situations, once a case is filed, automatic stay goes into place. It should stop all foreclosures unless you're surrendering the property. It should stop any creditors who are trying to garnish your bank accounts. It will stop the IRS from garnishing your stuff or imposing a lien or levy on you. So once you file your case, the timing of the filing of the case may be extremely critical, and it's something you definitely need to talk to your attorney about. The meeting of creditors usually happens about 30 days after your case is filed. So what happens? People panic about this. And quite frankly, when they're walking out, usually the reaction is, oh, that wasn't so bad. Well, it's not. The meeting of creditors is more anxiety and stress for our clients than it is practical problems. I've had people who spent the whole night, couldn't sleep. Then they get there, they go through it, and they're like, oh, okay. And no matter how many times I tell them, don't worry, don't panic, the attorney will be there with you. You just need to show up and answer some questions. And at our office, we send people out a letter saying, here's where you need to be, here's what you need to bring, here's what time you need to be there. Show up a little early so you can watch them going on. And then here's a list of potential questions they may ask you so that you're ready for this meeting of creditors. And routinely, people get there and they're still so stressed out. Now, granted, I've probably been to several thousands of meetings of creditors, and I know nothing's going to happen there that's going to blow my client away. And if I'm there, I'm not going to let a creditor do anything to hurt my clients. Are they allowed to ask questions? Yes. Am I going to let them berate my clients? Hell no. No way. I'm not going to let that happen. And it certainly won't happen because I think the bankruptcy trustees would step in if a creditor got out of hand. So the meeting of creditors is really nothing to worry about. You answer the trustees' questions as truthfully and honestly as you can. That's all we ask you to do. And then we get up, and if the trustee has any further questions, they have the right to for a larger examination because of 2004 exam. 2004 is a bankruptcy rule where the trustee can say, I need more information about this, that, or the other thing. Or a creditor can say, I want to talk to the debtor about this, that, or the administration of the case. No problem. We'll be glad to show up. We'll be glad to tell you whatever you want to know. The trustee may ask for additional documentation. This happens all the time. You got to remember, the trustee is going to get certain information from us. It's going to hopefully coincide with what we've said in the petition and schedules. But certain things need to be explained. I mean, let's say, for example, you've got excessive medical bills. You have a medical condition that require, just outrageous medical bills or outrageous amounts of medication. Well, I'm not going to send that to the trustee originally. Quite frankly, if the trustee asks for it, I'll provide it. But I don't really think it's relevant that I send them what type of medicine you're on. And I'm certainly not going to make it a matter of public record unless a judge requires me to. But I don't think that, and it's never happened to me, and I don't think any judge would ever do anything like that which would impinge upon your right to privacy. So you got that. What do you bring to the meeting of creditors? Two things. Driver's license, social security card, that's it. Of course, you got to wear clothes and you got to show up. But it's not a time to wear ball or evening gown. And the gentlemen, you don't have to wear suits. You have to. I would dress appropriately. You don't want to show up with pants around your ankles and inappropriate behavior or inappropriate clothing like that. An attorney will be with you. So, what you're really worried about being protected, or you'll see that the attorney's role at the meeting of creditors is very small. Unless there's an issue that we can help explain to the trustee that may not be present on the face of the schedules. Happens a lot. If something happens or there's something just doesn't make sense logically, we can help the trustee understand what exactly it is that you've set forth in your paperwork. And then again, if the trustee wants additional documentation, we'll be glad to get it for them. If they want a copy of a will or a trust or certain business things, I have no problem getting to them. So now that we've talked about the creditors' meetings, we've talked about, before filing, we've talked about the filing, and now we've talked about the meeting of creditors. The last part of today's talk, I want to talk about what happens post-creditors meeting, what you need to do afterwards, and the discharge.